Hello, fellow Toolboxers. Welcome to episode number 355 of the Immigration Lawyers Toolbox podcast. We have a great monthly interview with Kevin Gregg talking about federal court cases. Actually, the second half of an earlier discussion we had. We were going to record this earlier, or was recorded earlier, but it was right after the elections. And so we put our thoughts in to discuss what was just going on very briefly. And I put that as a separate emergency episode for practitioners. And this is actually the rest of that. It takes off from there, and at the tail end of it kind of gets to the election as well. So sorry if you have to be thinking about it all over again at the end of this one, but it's worthwhile stuff to say, and just the information there's always helpful, and we try to add our spin to it too. So without further ado, we get it started. Always remember this is not intended for individual legal guidance. Please consult with an attorney about your case. And also, if you're interested in an E2 course, our live E2 course is probably filled up by now. If you are interested in learning E2 and you want to just come to a live session that we do, a small room, we only have like 5 to 6 people in there. And we'll just go over a case that I submitted in detail. Like a lot of details you can't do it really in public or even recording. I'm going to put it out there and talk with y'all to help you through it because it's always unnerving. We've never done it before. It's first time, or maybe even several times you've done it. But you want to learn how it is if it's under 100,000. When I first started, there's this immigration lawyer that was doing like 3 E2s a month, charging like, I'm not sure if it's money, but essentially make a ton of money off these. And I'm like, oh wow. So I started like getting mentored by her and stuff. And she's like, never accept a case under 100,000. And so I turned down so many cases until I learned that message was garbage. And so almost all my cases are under 100,000 nowadays. So we go into that and what we did and all that kind of stuff. A legit case, we just break it down, what's going on. So if you want to get a wait list for the next one happens, email me at info@immigrationlawyerstoolbox.com. And if you want to learn family-based immigration in general, email me as well. But without further ado, let's get it started. What's the first case that you have?
Well, I only did 2 instead of my usual 3 because I figured we'd talk election a little bit, which we did. But they're both from the Ninth Circuit, actually. First is Singh v. Garland, which has got to be like the 15th Singh v. Garland. Not even joking that I've done on it. I don't know much about the Sikh culture in India, but I guess that there are a lot of similar last names. Like,
Yeah.
Singh is clearly an important name. I don't mean that like as a joke. Like, they're all 90% of them seem to be Singh, at least in the precedential decisions. And this is another one, which is ironic because this decision is about matter of RKK and the BIA and an immigration judge's ability to compare similar affidavits to one another to make an adverse credibility finding. And the Ninth Circuit said, at least as applied here, the matter of RKK was applied very wrong. Can't do it like that. So to the extent this is what RKK means, then that's wrong too. And that is this. In this case, Mr. Singh, Sikh individual, admittingly, as described by this Ninth Circuit panel, his claim, what he said happened to him, seemed similar to a couple of cases that I've done on the podcast. These Sikh cases where the person is a member of or affiliated with the Man Party in India, and they get attacked by members of the BJP or another party, the National Congress Party in this case. Similar things, similar factual circumstances occurred to Mr. Singh in this case, as occurred in other Ninth and other circuit decisions. And quite frankly, after the individual hearing, which is probably one of the reasons this happens, the IJ, I think, brought up this issue in matter of RKK, which permits an immigration judge to compare affidavits from other cases that aren't submitted necessarily. Well, they have to be submitted, but it compares to the non-citizen's affidavit and testimony in the case before the IJ. But a lot of things have to happen to protect due process, explains the Ninth Circuit, including, alerting the non-citizen of the issues and giving him an opportunity to explain. It's a multi-step process for matter of RKK. But what's important here, because you best believe that DHS will be doing this now in a new Trump administration, what's important here is to the Ninth Circuit, matter of RKK is not so much about factual similarities between asylum claims, unless like they're really unique factual similarities that you wouldn't expect to happen to multiple people, not just being hit with sticks as occurs in a lot of these Sikh asylum cases of late. But to the Ninth Circuit, it's more about grammatical, textual similarities in the affidavit. That's more what, when RKK comes into play and the immigration judge can make an adverse credibility finding based on similar affidavits. Not so here, where it's just similar stories that don't have unique characteristics. So if DHS starts doing this, and in this case, they even had a chart explaining the similarities between 20 affidavits and Mr. Singh's, this is the case. Unfortunately, it's Singh v. Garland, and so it's going to be hard to find it. So it's published on October 4th, 2024. This is the case to argue against what DHS is trying to do. And oh, by the way, I'm not sure, at least in the Ninth Circuit, DHS can ever do this. Putting aside the distinctions and the RKK requirements, the Ninth Circuit says that what DHS did here, providing these 20 affidavits, not explaining the ones that they rejected, by the way. I mean, they presumably saw a lot of Sikh affidavits and didn't bring the ones that weren't similar. So shouldn't that be in the record too? But in any event, what they did here, presenting these affidavits and redacting the identity information of the affiants, made it such that Mr. Singh couldn't, combat them, couldn't investigate these people to see if his claim was to show the distinction.
Yeah.
That was a due process violation to the Ninth Circuit, and quite frankly, I'm pretty sure it's a violation of asylum law for DHS to ever submit unredacted asylum affidavits in somebody else's asylum proceedings. So this decision to me stands for the proposition that I don't know if DHS can ever do what RKK indicates they can. RKK itself is two brothers. So that's different, right? You don't have all these problems, but like totally different asylum affidavits, not sure you can do it. Remember Singh v. Garland. The last thing I'll say is it also talks about State Department reports, which is something I'm always looking to undermine because, of course, they're so important to immigration proceedings. And this quote, an omission in the State Department reports about acts of persecution does not support the inference that this form of persecution is rare or non-existent, end quote. That's an important quote, because that logic is used. But of course, Department of State reports, they're just high-level reviews.
Not
they
doing
don't
everything.
get into the nuance. And, this inference by omission, not proper, says the Ninth Circuit. Remember Singh v. Garland. We got to start building up all the tools for removal defense and just USCIS anti-RFE litigation, too, because it's all coming. And that's what I try to provide on the podcast. That's what you provide in your interviews with immigration attorneys on the front lines as well. But start remembering your tools. And I bullet all of these cases on the Kurzban website for Control Find Research, so you don't have to be taking copious notes when listening to this or my podcast, because they're all there.
Very cool. Now, is it the situation with the asylum cases? Sometimes there's law firms that do like they're certainly like Indian attorneys doing all the Singh families are coming to them, so they they have a system of their affidavits where they kind of formalize it just to get it done, and it doesn't mean it's not a factual case. It's not, but it's just they're going through the same thing. So
yeah, maybe so. I would advise against it. I mean, I understand that there's a lot of cases and things take time, but it's not great.
That's how you make money in these mills. You have the same case and you change the name. The clients have
right,
a case, but they don't even ask them.
I'm anti-mill, right?
Yeah.
We shouldn't. I suppose it's better than no attorney, but there can be similar affidavits because similar factual things happened. But every case is unique, and if an immigration attorney isn't highlighting the uniqueness of every case, then I think they're doing their client a disservice.
Yeah. Big time.
But that brings me then to Mateo Gonzalez et al. V. Garland out of the 9th on October 17th. And this is about in absentia motions to reopen based on exceptional circumstances. And this is only this, you don't show up to your hearing, you get order removed in absentia. This is not the no notice cases that, I've been talking about to death, be it because you didn't receive a hearing notice or based on the deficient NDA thing. This is when you don't show up and you timely, which I believe it's 180 days post removal order, but don't go to the statute. When you timely move to reopen after you're missing your hearing because you totally messed up, an immigration judge still need not reopen it and permanently banish you unless you've missed your hearing based on exceptional circumstances. And the statute actually lists a pretty harsh rule. It says, quote, the term exceptional circumstances refers to exceptional circumstances beyond the control of the non-citizen, such as battery or extreme cruelty. serious illness, but not including less compelling circumstances. So it's actually one of the most specific statutes in the entire INA. And yet still, the Ninth Circuit and most circuits have held that that is not a conclusive list. I mean, there can be other things, so long, I suppose, as they are as exceptional or compelling as those examples. And in this case, Miss Montejo Gonzalez and her minor child, if I recall, they left with enough time to get to their hearing, but they ran into not one, but two, to quote LeBron, serious traffic
Yeah.
accidents
What a
that prevented them from getting to their hearing on time. And they showed up at, I think, about 10:30 a.m. Court was still open.
yeah.
I'm not sure if the immigration judge was still on the bench. And they asked the clerks, is there anything I can do? They were clearly trying to show up.
Mm-hmm.
Ninth Circuit says that's enough. Ninth Circuit said that in this case, and it's always going to be fact specific based on the totality of the circumstances, that was enough. And oh, by the way, it's proper to consider whether unconscionable results will occur absent this. And in this case, for example, the children's father was a U.S. citizen or had become one. And so deporting the children for something that was totally out of their control and not giving them the chance to have removal proceedings would lead to that unconscionable result as well. So, fact-specific analysis. Traffic accidents can cut it for in absentia reopening when timely filed. Again, we're not talking about the no-notice motions to reopen. But Montejo Gonzalez et al., some grace in the immigration court adjudication process.
You know, I was reading that, and I've had it where I'm going to the airport and there's traffic, and I'm like, oh my god, I'm gonna miss my flight. If I had, I can't. I was just thinking when I was reading that synopsis of that case, like if I was in the car and they get the accident, like I'm
Oh
gonna
my
be
God.
late. They must have been
Oh
just
my
freaking out in that car ride. It's not the worst car ride in their lives, and
God. Oh
I'm
my
like,
God. I mean, and if I'm not sure if it was LA. I feel like it might have been LA. I mean, not for nothing, right? Like Kobe Bryant, rest in peace. Like he was using
yeah,
helicopters to get around Los Angeles. You know what I mean? Like for a reason, and it led to a tragic result. But like, look, I mean, look, show up, leave with enough time to get to your hearing. Immigration court is serious, but
you never know with these.
there's
Yeah,
room
two
for grace.
accidents.
And by the way, the Ninth Circuit said that this aligns with First and Sixth Circuit decisions as well for those in those circuits. I recall the Sixth Circuit one too, by the way.
Good
I think that
decision.
was a
Yeah.
recent one I did on the podcast.
It,
Um, I don't know. I'm worried. It was a rough 4 years under Trump in removal proceedings and
yeah.
USCIS. But I still think what made it so rough is sometimes it felt like sometimes with some judges there was no grace in the judging. It was very strict, holding non-citizens to a standard sometimes that's impossible to meet or that doesn't align with how the world actually works.
I think that grace
I'm
part's
not
really
saying
good.
that I'm not saying
Really.
that necessarily you should have your case reopened when you're tardy or because you hit a traffic accident, but you know, immigration judges, even under Trump, judging with grace.
Yeah.
I think that's what a judge is supposed to do. And
Yeah.
nothing that Trump will do or his attorney general should take away from that.
That's the perfect way to put it. The grace that role is, I mean, judge or judges is part of the requirements. There's a spirit of the law there that allows for grace, especially that situation. I can't believe they would like do that to people, but it happens.
To what end? To what? I mean, look, don't get me wrong. Judge Collins dissented in this case. Judge Randy Smith dissented in the first case. I did. Reasonable minds can differ, but to what end? Eternal banishment of a family based on a technicality when they've tried to do everything they could to show up.
Yeah.
You know. Anyway, so it's good to have the precedent in the Ninth Circuit. It turns out that Miss Montejo Gonzalez and her children might have been right all along. So that's why case law is so important.
Yeah.
That's why when I'm doing this, like I say my thoughts, but like it doesn't really matter what I say. It matters what these courts say. It matters what the BIA says, and so this is what the Ninth Circuit said in October.
There's another case. It wasn't. This is not really immigration. It is immigration law, but at least the way Justia puts it. But it annoyed me. So the FBI or whatever, the government asked these Muslim men to become informants in their community, and they said no. And as a retaliatory measure, they put them on a no-fly list. And I was
Yeah,
like, it's
I
like
saw
this
that.
is disgusting, like just like abuse of power. Unfortunately, they lost still based on the Religious Freedom Restoration Act. They claimed damages, but it's just like that stuff's gonna. It's already happening. I think that's doesn't matter who the president of administration is. This is the kind of stuff the government does. But that was like annoying when I saw that to put them on no fly list. I mean, they're putting more and more people on these lists, and that's a very dangerous maneuver.
I saw that case. I didn't read it. I didn't know if there is a if the facts did show that they were put on it in retaliation and all of that. But of course, if that is the case, that's horrible.
Yeah, I read the sentence says when they refused the agent's place to retain them on a no-fly list, suggested they could be removed from the list. They agreed to work as informants. But this is a synopsis. I read. I do read all the synopsis. So every time you're talking, I'm like, oh, I remember reading that. That's as far as it goes. Well, thank you for coming on, man. I mean, we're gonna be. We got once a month. We got 4 times 12. We got 60 more of these at this
Wow.
administration. So we're gonna have a lot of talking to do.
Yeah, and I'll be more upbeat. I usually try to be. It's very hard. We're talking on November
Yeah.
6th. I haven't been. I woke up in a panic after turning my phone off because I couldn't do it again. And then lo and behold, it did occur.
Yeah, it's less than
What I
24
feared.
hours. Yeah.
And so it's pretty raw. I think I speak for everyone. I'm not sure when you'll post this. We'll get through it. We'll see some horrors in the next 4 years. I hope it's not as bad as everybody said in immigration and beyond. But you're right. Even if it's horrible, we're blessed.
Yeah. And it
We're
seems
blessed.
like some people he's brought aboard a team between like even Elon Musk and Kennedy and stuff like that. They may be less like I don't know, have some influence. Be like, no, wait a minute, it's not like less hardcore on some things. We'll see how it actually
You're,
works
you're,
out.
you're talking about the guy who said he literally had a worm in his brain. I'm sorry. I'm not going to put my faith. I'm not going to put my faith in the worm brain guy. But
Is that Kennedy? Is that or it's
yeah,
Elon? Okay, okay.
the worm brain guy who put a dead bear in Central Park. His words, not mine. But we'll see what happens. No need to get ahead of the horrors. Maybe they won't occur.
Yeah, I mean, between now and then, World War III could start. That's so. Who knows? That's gallows humor. So, well,
Mm.
good to see you, man. We'll get through this, and that's what our podcasts are for. Who knows? We have some really good podcasts may pop up out of this. That's going to be real game changers in promoting our field and helping our clients out to take things to the next level. Thanks a lot, Kevin. I
Good to
appreciate
see
it.
you.
Good to see you too, brother. Stay online a little bit. We'll talk for a sec, but thanks for everyone for
Yeah.
listening. Thanks again for listening to Immigration Lawyers Toolbox podcast. A great guest we always have, a regular. I'm not sure if he's considered a guest as opposed to a host on the show. We'd love to have Kevin come and just do a one-man show on here, but until he has the time to do that, I would thank him for coming once a month. Again, if you're interested in getting on our E2 Visa Live private seminar for lawyers, just email me so you're on the wait list for the next one that pops up, info@immigrationlawyerstoolbox.com. If you want to join our free community page and you're a lawyer, also send your bar information. We get you on there, and you get access to a bunch of CLEs and free content. Again, the email is info@immigrationlawyerstoolbox.com. If you send that, I'll see you next time. Bye-bye.